All right, welcome everyone to the fourth session for our small ruminant backyard farming series. My name is Megan Purdue. I am the ag agent in Worcester County, Maryland. Our speaker today is Paul Geringer. He's our extension legal specialist for the University of Maryland. So Paul, you can take it away.
Okay, thank you, Megan, and good evening, everybody. Hopefully everybody's had a good day. Hopefully my screen is sharing, and I'm gonna make y'all smaller so you don't distract me during it, and I can see my PowerPoint. So yeah, Megan asked me to talk today sort of about signage that you would want to utilize on your farm to protect it. So we're going to talk a little bit about that and sort of why you might want to consider it. If you have questions, just put them up in the chat and I will try to look at that periodically to respond to them. University programs are open for all. We should not discriminate against you based on any reasons. We're also funded by USDA.
This institution is an equal opportunity provider. This
None of this is legal advice because I am an attorney, so hopefully y'all are all good with that. And I'm glad this is being recorded, so I have that on the record. I'm also with the Ag Law Education Initiative. I'm at College Park. We have staff or faculty at University of Maryland, Baltimore, at the law school, and then at University of Maryland, Eastern Shore with the School of Agriculture and Natural Resources. We're funded by University of Empower. You can find more of our information at umaglaw.org. I have some fact sheets up there if you're curious about any of this later with landowner liability. We'll do a lot more landowner liability stuff. We're going to hit it a little bit tonight, but if you want to do more in-depth stuff, that's what we will do a lot of on the 22nd and the 29th, because oddly, that's where most of you have your questions as to what happens if a trespasser gets hurt on my property. So we'll cover that really in depth on those dates for that event I put in the chat earlier. And that's all free to sign up thanks to the Northeast Risk Management Education Center. It's also an online class associated with it. If anybody wants the link, I can send it to you and you can sign up for it. My contact info will be at the end. Keep going. So the biggest thing we have to talk about with all farm signage is just thinking about all of this from a negligence standpoint. Anything you're doing when you're putting signage up on the farm, whether it be for a farm dog that's out protecting sheep, cattle, any livestock, or we've got livestock out and we're putting signage up to make folks aware. We're really thinking about it from a negligence standpoint with that. So what's negligence? Negligence really is within the eyes of the law. It's something we took from common law from England when we were a colony. And then when we broke away, we kept it because we were all still sort of English and we still liked the English legal traditions. So we kept them. With this just being the idea within the law is it's a failure to exercise a duty of care under the circumstances. So in various circumstances, as we all go through life, the law will recognize that you have a duty of care in certain situations to keep others from being harmed, and vice versa, others have a duty of care to prevent you from being harmed. And as we go through this, we'll talk a little bit about what the signage does within that for some of the defenses that would apply to negligence and why signage is actually a good idea and doesn't admit to any fault at any point. The other way to look at this is negligence is sometimes just simply defined as the failure to act as a reasonable and prudent person would under the circumstances. So if we end up in court at any point and it's a negligence claim, the idea within the law is we would look at this from what we would think a reasonable and prudent person would do. So my example I use in almost all situations from my undergrad class to anything I teach with this is we've all driven today probably at some point or driven over the weekend or, at some point. So what do you expect people to do when you're out driving? Well, we expect them to sort of follow basic motor procedures, follow the speed limit, not be speeding, not be texting and driving, brake at the times when we're supposed to brake, stop when we're supposed to brake. So we expect people to do that. So if we're doing a lot of that and trying to follow those rules, we're acting as a reasonable and prudent person would under those circumstances. The issue becomes within this is when we're having a negligence claim, depending on what it is, thinking about in this situation, depending on the facts of the situation, what would a reasonable and prudent person have done under those circumstances and how would they operate in those cases? Like anything we do within the law, sometimes we have to look at what the elements are for that. And we'll not going to go too in depth in this because then we're going to move into what livestock liability would look like and why this signage is important. But really within it, we're looking for the fact that you owed a duty of care under the circumstances. You don't owe a duty of care in all situations. You do in a lot of situations, but we really do have to think about, did in this situation what you were doing create something to where you owed a duty of care to the individual that was hurt? If you don't, we don't have a negligence claim, but if you do, then we got to start keeping going down. Did you breach that duty of care? So if I go back to my driving example, if you're speeding and texting while driving and hit somebody, you've clearly breached the duty of care because we expect you to not do those things in that situation because that's not what we would expect a reasonable and prudent person to do in that situation. That breach has to be the proximate cause of the injury. The way to look at proximate cause in all of this, and we're not going to go through this in depth. Luckily, you're not my undergrad class and going to be tested on this, as many of them will be in about a week. Proximate cause, the idea of it is at some point, we have to cut off liability for an individual who has created the problem. We have to make sure that whatever this injury was something that we normally would expect to happen. As I always point out, there are sometimes just some accidents that are so weird and so random that we can't account for them and we can't prepare for them. So at some point, we really do have to cut off liability for a person and just say, no, I'm sorry, you were hurt, but this person's not at fault. It's just so weird. We're not going to do it. Most of the things we're going to end up dealing with in normal everyday life, it's easy to look at proximate cause. There are certain situations where it's going to be really, really weird to look at. And then the final thing we look at is always just where their actual damages. What are the monetary damages that the person was facing in this situation? In almost all negligence cases, especially when we're dealing with livestock, we're looking at what are the actual monetary damages? How much money is this person out for the injury? So is that doctor's bills? Is it damage to personal property, other property? What are we looking at that we can put a dollar amount on? And this, if we're going to court, courts really just want to put money on something because it's easier to put money on stuff than to figure out other ways to associate damages with the injury. We can make you whole by giving you the money you're out for doing this. So we go back to my auto example. If you cause the accident, what's it going to cost to repair the person's car? What's it going to cost if the person's injured? What are their medical bills? What are things we need to think about that they may have to deal with long term? Do they have a neck injury where they have to go to medical treatment for a long period of time? What are the things we need to think about in all those situations? So how do we just put monetary damages on it in that way? You got to prove all these elements. If you fail at any point, you lose. We're going to go through a couple of examples with livestock liability. And as I always point out, proving this really does depend on the facts of the situation. I can give you examples, but if we change the facts up, it may change whether or not the person's liable or not. And feel free to put questions in the chat box at any point. So really with all this, we're thinking about livestock liability. If we're thinking about animal and signage that we would put up to make people aware of either dogs or other animals, and I've got some pictures, I think, as we go along looking at this, what are the things we normally would expect with livestock liability? The first thing to point out is livestock owners can be liable for the damages caused by their domestic livestock. If you're outside the domestic animal range, we can get into that. But for the most part, tonight, we're just going to focus in on domestic livestock and domestic animals. We're thinking about livestock, cattle, sheep, goats, horses, chickens, stuff like that. Stuff that we normally would expect people to keep. If you're keeping a pet tiger, we got other problems That's going to be a different set of liability in all of this. That's going to be a different negligence standard, and we can talk about that. If you're keeping tigers, we can talk about that later. We can also talk about choices in keeping tigers at your house. Or do you want to be a Netflix documentary at some point in your life? The other thing to keep into account with this is also includes dogs, cats, other domestic pets we may keep in our house. It can include other animals, but we haven't seen court decisions on that. So it's pretty limited right now to just the animals I've listed. We could go out beyond that, but right now we don't know where that would be. So with this, we really do have two theories. We have negligence, which I just kind of walked through sort of what those elements would look like. The other one is strict liability. With strict liability, we don't care what you did. What you did is so dangerous. We've just decided that if anything happens with it, you're liable for the injuries. So if we go back to my tiger example, if you're keeping tigers, we're keeping you under a strict liability standard. You're going to be held liable for any damage those animals would cause in that case. And those are going to be pretty rare. We're much more going to be focused in on the negligence standard. There are a few cases where we would focus in on strict liability with domestic animals, but that's mainly going to be with dogs that have a propensity to be dangerous. So we're looking at pit bulls and other type of dogs that the courts have determined are much more liable to be dangerous, whether or not they are or not. I'm not here to debate that tonight. I'm just telling you that courts have usually found those to be under that strict liability standard. So for most pets, most domestic animals, we're going to be dealing with negligence. A few we might deal with strict liability, and certain animals, we're just always going to deal with strict liability. Like I said, strict liability, I got ahead of myself. It's a form of negligence, except we don't have to prove any elements. You're just liable regardless of what happens. With it, we often have to look at, like I said before, this idea that the animal has caused the injury, or the animal or the owner should have known of the natural tendency for the animal to commit the injurious act. That is almost always with dogs and tigers. But like I said, it's almost always with dogs that we believe naturally have a propensity to be dangerous, such as pit bulls, Rottweilers, other dogs such as that the courts have often viewed as much more dangerous than other animals. Now, with this, there have been areas within the law where courts have automatically found dogs to be liable with this, even regardless of what they are. So take into account what I said. Once we move past a certain standard, courts may be that. Find that. When did they find that? In Maryland, they found it when a dog owner had a dog that had a history of barking and growling at a usually gentle horse, which caused it to bolt and throw a child rider. There, they basically said because this dog had a long history of doing this and they could prove it in court, the owner should have known this automatically and kept it away from situations such as this. The idea here is you knew the dog was going to do this. As we're going to go through this a lot with livestock, especially with dogs and other livestock. Well, dogs aren't livestock, but dogs and then livestock is, if we know this dog or this livestock has naturally just created these problems over time. So we have a horse that naturally is always throwing riders. We have a cow that naturally charges anytime someone's in a pen with it, horse or sheep, goats that do that too. This is where we're going to start getting into strict liability. So we're going to move past just looking at the normal things we would look at for strict liability and then move into other animals that could be considered in that. So normally we're only going to consider certain things but if the dog or livestock has a natural history of being this type of animal to where we know that they can cause problems, we're much more likely to hold them to a strict liability standard. This will lead into some of the signage issues here in a second that I'm going to talk about. With that, because the court viewed and they could look at the history that was presented At trial, they looked and said, yeah, the dog owner can be held strictly liable for the injuries because it had done it in the past. The dog had a long history of causing this type of damage, so they weren't going to let the owner off the hook this time when that happened. Does that all make sense so far? Because I can go back and explain this better. Seeing no one typing questions, and I'm just going to keep going. Now, with negligence, so that's strict liability. That's a rare case where we're going to find strict liability. With negligence, it requires the injured person to show that the owner failed to exercise effective control when it's reasonable to expect the injury to occur. So we really have to show that the owner failed some control. We're going to get to signage, don't worry. This all leads into signage. With this, if we go back to the standard I set out, the duty of care when we're dealing with livestock or pets is we are exercising effective control when it's reasonable to expect injury. So when would we expect that to happen in a lot of this? So we're dealing with horses, we expect, okay, what's a reasonable injury we would expect? And how do we go about preventing that? So we may want to make sure that if we're offering riding services, we're providing horses that are gentle, that have a history of not throwing riders. If we got petting zoos or sheep, goats, stuff like that out, we're going to want to make sure that these are animals that have had a history of not biting folks. Now, this doesn't mean that if someone's there that day and they have a child, I'm being recorded, so I can't use the words I want to use, that has a tendency to be pain and poke at the animal, do stuff that would irritate the animal to where it might bite or do something like that to protect itself, that's a different case. That's the person creating the problem. And we can talk about how that would be a defense here in a minute. But normally all we're looking for is did you, utilize some reasonable control when it was expected that it could cause injury. So my example is, and this actually is a Maryland court case, you run a stable that offers rides on horses you own. You take a group of first-time riders out with horses and you have a friend come along with you haven't seen in a long time. You're talking to the friend the whole time. You're not paying any attention to the riders. You miss seeing a horse get spooked and throw a rider, and that rider breaks their arm. That's a case where the court said, yes, you're liable because you were out with people, you weren't paying attention, you were off doing something else, you should have been paying attention to them. You should have known that your duty of care was to keep them safe when animals could do that. So that's a liability case. Most of our court cases in Maryland are pretty limited in this, where we haven't had that many court cases go before the Court of Appeal or the appellate court and then the Maryland Supreme Court. Any questions so far? In that case, you would be potentially liable for damages. The court did say in that case they were liable, but the party that was injured really did have to go through and show that there was a history that this could happen if a horse was spooked, that it could be doing that if you weren't exercising effective control. That's usually a pretty easy standard for most people to show, especially if they're new riders. They haven't gone through this. I will say this, almost all the court cases in Maryland where we do have the few animal cases we have, there are almost always people that have riding stables not following, basic safety procedures at some point, or, they have safety procedures in place and something happens that day. It's just a bad day and somebody gets hurt. It happens. I will say the biggest reason why we probably do not have a lot of court cases related to this is in many cases, folks are carrying insurance that we'll talk about at the end that sort of prevent this. So where I go much further, we got signage involved in this. What about signage? Do you think signage protects you or helps show that you're potentially liable? What if I have a beware of dog sign up? And I'll let you type in the chat because this will give me a second to take a drink. If I can get the chat to pop up. So I see some people saying liable. Other people saying liable because it shows potential risk. What if the dog's never bit anybody? What if you're just telling people you have a dog in your yard? Does that change anybody's opinion? You guys respond to me the same way my undergrad class does when we go through this. Sarah says not liable. Sarah is actually correct in this one. You're not liable. All the sign does is tell people you have dogs on the premises, and I'll go through some Maryland court cases. Same would go for any other livestock. I got some examples in here in a second of beware of goats, beware of every type of livestock animal you could have on your farm at various points. So yeah, signage is never going to show you're liable. So I forgot I had these in here. I'm not looking over at the side of my screen that gives me my presenter view. So yeah, I have a beware of dog or warning beware of dog, beware of dog. This property is protected by video surveillance and dogs and a no trespassing sign. The sign on the right is actually a really good sign, especially if you don't want people trespassing on your farm. You have it under video surveillance and you have a dog on the property. It puts everybody on notice as to what is expected when they're on the property, especially if they're not supposed to be there. And we can talk about what your liability would be if they're trespassing here in a second, if you want to go through that. I don't have slides on it, but we can talk about it. So, as I said, and was put it in the chat, beware of dog sign does not mean you have a dangerous dog. It simply means you are warning people that you have a dog on the property. We have some people in society that these are weird people to me. They don't like dogs. You're just making them aware, especially if they have concerns about being around a dog. You fully made them aware you have a dog on the property and they should look out for that or they should not stop. I walk through DC a lot. There's an area I walk through where there is a large dog that will bark at you all the time when you walk by this person's house. The dog, there is a sign outside that basically warns you. The dog will bark at you. Do not pet the dog. Just leave the dog alone. It's very clear to us what we're supposed to do. The dog, when we walk by, will bark at us and we keep walking. Now, if we pet the dog, we're at fault. We'll talk about why that here is in a second. We only have one court case in Maryland on this. And in that court case, and I'll talk about what this means here in a second with what assumption of the risk means. The court found because it was kind of in just a part they didn't want to deal with that day, and they kind of just hinted at this may be the case. They potentially said, look, it's assumption of the risk because the person was made aware that the dog was there. And if they get bit, they should have been aware and they were knowingly confronting a risk that they were told about. I need to make a note. He was suing after he got arrested for breaking into the property and bitten by a dog. So one of the reasons why the court really didn't want to deal with this issue is they were dealing with a person who was already doing a whole bunch of other things and they were trying to get rid of the court case as quickly as possible without touching this issue. So that is potentially one reason why that's there. But it is out there to make us aware that for the most part, the Maryland courts have said, look, this is assumption of the risk. So what does assumption of the risk mean? This is why we went through all of the negligence stuff. Assumption of the risk is a defense to negligence. It's grounded in this theory that the person that's injured, the plaintiff, voluntarily, either expressly or impliedly, is exposed to a known risk, and they can't sue later for damages from being exposed to that risk. So I put a picture in here of Wile E. Coyote and one of the things he gets from Acme flying. What happens when Wile E. Coyote crashes? He's going to crash. He won't in this gift because it's just a loop of him flying. But what happens if he crashes? Can he sue the Acme Corporation for his injuries? No, can't. Because he's knowingly confronting a risk. What happens if we fall out of the sky? Do we get hurt? Yeah, we're going to get hurt. We're knowingly exposing ourselves to a risk in this case. So if we get hurt, we can't sue. If we have a beware of dog sign, we're knowingly exposing ourselves to a risk. We're probably impliedly doing it because nobody's ever going to get us to sign a liability waiver. and we're confronting this risk and we're being exposed to it and then we're injured. We can't sue. So these signs often provide us with a good defense for assumption of the risk later and can help protect us. I do need to cover some types of assumption of the risk. Assumption of the risk can be expressed where you actively have the person sign a liability waiver saying they understand what the risks are and they're knowingly confronting it. This normally happens if you ever go skydiving, you're going to sign a waiver that basically states you could die while doing this, and the company that took you out skydiving can't be sued. We often see this a lot more too with agritourism. In some cases, we'll often see it. I think gyms often use it, and riding stables often use it. Now, there have been some changes to state law that make liability waivers a little harder to use in certain situations. So if you actually want to use one of these, you should talk to an attorney to make sure you're actually going to get one that works for you under the state law. It really does prevent entertainment venues from doing that. So if you qualify as one, that may be a case too. You'd also sign this if you're going to go skiing to anywhere at one of the ski areas in Maryland too. Implied is just based on the situation and what you ended up doing, we can assume that you understood the risk and you just voluntarily confronted it and you understood that you were implied assumption of the risk in this situation. That doesn't relieve you of any fault of your own in this. You're still at fault. My example is, which actually did happen in a Maryland court case, you attend a kid's baseball game. As a spectator, it's implied that you have some risk that you may get hit by a baseball. A parent was hit by a baseball that was hit, tried to sue the ballpark for what happened. You can't do that in this situation. That's implied assumption of the risk. We all know that we could get hit at some point if we go to a sporting event with either a baseball, a football, something could hit us. Now, there may be things outside that we normally would expect. It's not going to be assumption of the risk. That's very clearly. So if we're dealing with livestock and we've got the signage up that says, beware of goats, beware of horses, beware of cattle, beware of sheep, beware of whatever, and we still have people come out and get hurt, that's going to be a good way to show some implied assumption of the risk. Any questions so far?
You've got one in the chat box.
Oh, I got one in the chat box. It never popped up. Now it popped up. Oh. It's a good question. You probably should get them to at least, well, you probably can't get the 4-H'er to sign it, but you should get their parents to sign something that says that at least they understand they could get hurt or the animal could perish in that situation. Yeah. I should point out you have to be over 18 to sign one of these liability waivers. If they're under 18, you can make their parents sign it for them. And the other thing, because I don't deal with 4-H'ers a lot, and my guess is Megan doesn't either, you may also want to check with the 4-H agent because it may be implied that it's covered under whatever the university policy is too. But I don't deal enough with 4-H'ers to know if that's actually a good example or not. Okay. So to do all this, much like negligence, we have elements you have to prove. You have to have knowledge of the risk of the danger. So with livestock, we have to know that the person had some knowledge that, goats can bite, goats can jump, sheep can bite, dogs can bite, cattle can bite. Cattle can charge, sheep can charge, goats can charge. At various points, there's danger associated with this. So there is actual knowledge. If they're kids that have been around goats or they're people that have been around goats, sheep, cattle, horses, whatever it is, we can assume they probably have that knowledge. By getting them to sign a waiver, we take away all of these elements, but again, you'll want to talk to an attorney about how to get them drafting a waiver, and I can give a name of an attorney that's really good at drafting waivers in a lot of these cases and has been paying attention to the recent law changes. You have to appreciate the risk, so you actually have to not only have knowledge, but you have to understand that, if this thing bites me, attacks me, does something to me, I could actually get hurt. So you actually have to do that. Again, a liability waiver helps with that because you can spell out what all those risks could potentially be and lay them out so people can look at them and be like, oh yeah, now I understand all this. And you actually have to voluntarily confront the risk. In almost all cases, everybody's going to voluntarily confront a risk. There's going to be the rare situation where somebody holds a gun to your head and tells you to do it. At that point, you no longer voluntarily confront the risk. You're not voluntarily confronting, and you have not assumed the risk. You're doing it for other reasons. So we have to pay attention to that. But that's going to be a pretty rare case where we actually don't voluntarily confront the risk. And I should point out, I believe in at least the court case associated with this involved an employee getting injured at work. So for the most part, assumption of the risk can follow us around. There's one other thing I did not put in this that we could talk about too. Because we still have some time left. We have about 10 minutes before I wanted to get to questions, and I have like a few slides left that we can get to, but we can talk about this briefly. The other thing that exists in Maryland law is the idea of contributory negligence. So if we go back to my negligence slides, and I don't want to go back that far, with all of those elements, I showed you those 4 elements. You also have a duty of care to protect yourself in situations where you could get hurt. So in Maryland law, if you voluntarily don't protect yourself and you still get hurt, or you're being negligent in the way you are hurt, you lose if you go to court. You have to be 1% at fault to lose. In almost all cases, we can show you're 1% at fault. So in a lot of cases, Maryland tort law actually does protect you really well in a lot of cases against a lot of this damage, because almost always if somebody's injured, they're going to be at fault in some way for the injury that was caused to them. As I point out to my undergrad class every time, as much as bad as it may be to tell people, it really is blame the victim in that case, because you really are blaming the person hurt for their injury and how they could have protected themselves better and how you tried to do as much as you could. But it can be, if you're in Delaware, that's not the same. It'll be based off the percentages at fault for each party. And if you're in another state, tell me and I'll let you know. So then no trespassing signs, because this kind of fits within that. 2, and the final thing that most people always want to know about too, is that we're doing all this. We could also put up no trespassing signs to keep people off our property. So the first thing we need to realize is there are 2 types of trespassers, civil and criminal. We're only going to focus in on civil trespass. A trespasser is anyone who enters your property without your consent and remains on your property without your consent. Somebody's walking across your property, thinks it's a public trail. You don't give them consent to stay on, and they continue to walk across it, even if you don't talk to them. They're still a trespasser because you never told them they could be on the property. We want to get into the criminal part of this. I'll hit it briefly. This is the 4 times you can be criminally trespassing in Maryland. You have property posted clearly with no trespassing signs and the person still comes on. That can either be posted with no trespassing signs, or according to DNR regulations, you just have to put blue paint marks on trees on the boundary of the property. In other states, I don't know where everybody's at. I assume everybody's in Maryland. In other states, it may be purple paint. It just depends on the state as to the color of paint. That person pulls on to a property that's clearly marked as a private driveway with a vehicle. That's also trespass. If you tell them to get off the property and they stay on the property, that's criminal trespass. And then my favorite, which a lot of people don't realize in Maryland, is if they enter cultivated land or land cleared of its natural vegetation and is being used for crops or orchards in some way, that is also criminal trespass in that case. They should have known, they shouldn't have been there. If any of this happens, sadly, you have to call the police or the county sheriff. Get them to come out and deal with it. It's no more than 90 days in jail or a $500 fine. So it's not a big penalty, but still, if they're criminally trespassing, please call the police. Do not try to deal with it on your own. That just creates other problems. I'm glad I'm being recorded, so if anybody gets hurt trying to deal with that, I at least have some protection to say, no, I told you to call the cops. Now for civil trespass. We're really looking for the same things. We got three elements in this. They occupied or exercised some control over your property. By walking on your property when you don't give them permission, they have occupied or exercised some control over your property. That exercise or some control of the occupation of your property occurred because of the other person's physical act or force against your property. They walked on your property. That is the physical act. That is all it takes. The force could be they just threw a baseball on your property too, or put something on your property. That's force. And they did it without your permission. If they do all this, most of the people we're going to end up dealing with are clearly going to be trespassers. So here, if we have this, all they're going to be liable for is the damages caused by trespassing. So we go back to a portion, it could be a crop field, it could be a pasture, whatever it is. If they tear up a portion of the field, the pasture, whatever it is, by riding an ATV on your property, that neighbor's committed trespass. We're going to have to figure out what the damage is to that property, and that's going to be what you get. It's going to be the monetary damages associated to it at any point. Any questions so far? Oh, I'll let that person in.
There was one question about do you know if Texas has a legal person?
They do. You can talk to Tiffany Lashmet at Texas A&M. I'll be on a phone call with her tomorrow. But you can look Tiffany Lashmet up and she will probably respond to you quickly. And she's done all this for Texas too, so you can, she has resources out there for you in Texas. Yeah. So if we got this nut trespasser out there and they're out there and they get hurt dealing with your livestock in any way, you're only owe them, going back to our duty of care example, you only owe them a duty of care to act to refrain from willful and wanton injury. Willful means you performed it with actual knowledge, or what the law would deem the equivalent of actual knowledge of the peril to apprehend, coupled with a conscious failure to avert injury. Wanton means the conduct is so dangerous, so extremely dangerous and outrageous, it is in with a reckless disregard for the rights of others. Would anybody like to guess what this means? You have to go out of your way to hurt these people. If they get hurt, if the livestock bite them, that's not willful and wanton. That's their stupidity. Now, if you set stuff up that hurts them while they're on the property to get them injured, that's on you. And I think my next slide is an example on that. And I forgot to wear my t-shirt tonight related to this. This is an actual court case out of Arkansas. Landowner got really tired of ATV riders crossing his property to access. Basically, he was in between two public trails. He got tired of ATV riders riding across his property to get to a public trail, or between two public trails. He strung an unmarked cable across his property to prevent people from going across the property. One ATV rider, a child, was severely injured when crossing the property. That's an example of willful and wanton. We've now set something up that can create the injury. That's going to create this problem. That's going to create liability for us. I jokingly said I did not wear the t-shirt for this. How many people know what Little Abner is? And I should bring like the chat box up so I can see. See if anybody responds. Does anybody know what the cartoon strip Lil Abner was? Or is? I think it still is. Yeah, so in the state of Arkansas, some guy in the 80s believed that the brilliant idea was to create a Disneyland related to Lil Abner in rural Arkansas. Yep, that would be it. And created this theme park. Well, the theme park failed, and he's now in between two public parks. So he created this. He no longer owns this piece of property, and the state of Arkansas does because of this court case, and is now attached to the public trail, and no one can ever ride across it. It was called Dog Patch USA. So I have a T-shirt that says it's a great day to be in Dog Patch USA. That was a shirt they used to sell at that theme park that I like to break out whenever I talk about this court case with my class, because most of them have never heard of Lil Abner. So why do we want to do this? Signage helps you meet all the qualifications to get across for the law. You can easily get criminal trespass. It also puts people on notice that if they're injured on your property, they're trespassers, and your liability is pretty limited if they get injured. Pretty much if they get hurt, they can sue you, but they're going to lose. Now, mind you, if they sue you, your insurance company may settle with them. That's not your fault. That's your insurance company's fault. They're going to weigh risk at that point. But for the most part, if this is going on, you're not going to be at fault, and you should be better protected. So a lot of signs we want to put up on the farm, whether they beware of dog, beware of livestock, beware of whatever, no trespassing, they really are going to help us in a lot of situations deal with a lot of the issues we may end up facing. And I did all this so I could take 15 minutes of questions. All this liability with livestock is going to depend on, the duty of care you own. The signage really is going to help you, because it really is going to help show, at least in some cases, potentially some assumption of the risk, if they could go out and, then see that signage to do all that. The other thing, and I'm not an insurance agent, so I try to refrain from talking in a lot of cases about insurance in this, but really, if you're concerned about a lot of this, you really should talk to an insurance agent, especially the one that's carrying your general liability insurance, just to make sure that they may have signs that they want you to put up to help protect you better. So they'll may have the signage that you can just easily get from them to put up around the property. That's going to help you in a lot of cases, and may help them with some of the policy stuff they're working on with you to be able to do this. And I have one other thought at the end of this too. All of this is good. Insurance is good. Signage is good because it makes people aware, like I said, of the dangers. None of this is admitting fault to anybody. All it is making people aware that the issue exists on the property. It helps limit a lot of the cases we may end up with this. The other thing to point out, and I don't have the link readily available, and I meant to get it before this all started, and I forgot, but it's on the extension website, and I can find it here in a minute while I'm answering questions, is a long time ago, I was asked how many signs is required. For the one person in Texas, I do not know the answer, but Tiffany will know the answer to this question. How many signs should you have up on the property? In the state of Maryland, the criminal trespass statute just says signs with an S. It never tells you how many signs you actually have to have up. So I was asked, and I created a sort of list for you to go through to come up with an answer for how many signs should be on your piece of property. If you come up with one on the list, you have failed at my results, because you should come up with multiple. So as I keep pointing out to everybody, the law says signs. So as long as you have more than one sign up, you should be doing good. Normally we try to get folks to put them up on all the pieces of property corners that would face the road and at easily accessible points where they think people would want to come on their property. And that's a good way to get it. Any gates, any other spots, just putting them up. I believe at one time with the poultry team too, they had biosecurity signs that also told you no trespassing, that were also really good. No trespassing signs. I do a blog at agrisk.umd.edu. I have a podcast available to there, although I haven't done episodes in a while, mainly just because I have been so busy. I haven't been able to record anything or talk to people. Feels like in a while. I'm also a part of a group with the Southern Extension economists that do a bunch of legal farm management, ag policy, trade. I'm trying to think what else. Specialty crops, livestock, whether it be everything from cattle down to sheep and goats. A whole bunch of stuff we do at southernagtoday.org. It fits in with a lot of the stuff folks are doing in this region as well. So check it out at southernagtoday.org. I think I have a blog post coming out on it on Friday. And don't ask me what it's related to because I can't remember what I wrote 2 weeks ago. What questions do folks have while I bring my contact info up?
You can put them in the chat box or you can unmute if you want to.
Feel free to unmute. I feel like I'm talking to myself right now.
I'll ask one. We're talking about livestock guardian animals specifically. Next week, the most common one that a lot of people have is a dog. So if you have a sign that says that you have a dog there, beware of dog, but your dog then gets out, as these dogs are prone to do, and goes and bites the neighbor or kills the neighbor's cat. Does that sign any protection to you? You're still going to be at fault because you're
Okay, so yeah, that's a good question. No, I forgot to cover this. So with dogs, in almost all cases, we give dogs one bite. After that, after the first bite, they are considered to be, we get into strict liability at that point. So if they get out the first time, yeah, that's bad. But after that, we're going to start having problems usually. And animal control may get called in the state too in that.
So there's another question about livestock guardian dogs.
I wouldn't say each gate, but just putting up one or two signs around the farm just to make sure folks are aware. Every gate's probably a good spot to start with, but you could also just put it on like each side that faces the road. It doesn't have to be a gate. But gates are good spots because they're naturally where people are going to try to break in at. I gotta get rid of the participants because I can't read all that at one time.
What about electric fences? Did you have a sign up that says that you have electric fence, that the fence is electrified?
You
'Cause
should.
they're included now. They are included in some of the netting, especially. I've noticed that they have them on there. I mean, they're not likely to kill you, but cause major harm. Unless you have a really bad, really terrible charger.
I would say, yeah, you want to put that up. And I see that someone sent me a question. Michael, if you want to email me about this, I can talk to you about this and I will send you my email. Mainly because it's probably going to be better if we have a call later to talk about that question. Chickens less likely to need signage. Chickens probably less likely to injure people. Other animals, it depends. The bigger that they may injure somebody, yeah, you might want to, but chickens,
What about mean roosters?
Mean roosters, you probably want to. Honestly, if people aren't coming on and they're far enough away from the road, they're probably less likely to need signage. But if you're in a heavily populated area where people may get on, you may want to put signage up.
And we'll say that we do recommend you keep your chickens contained for biosecurity reasons.
Yeah.
Not use a guardian chicken or a guard chicken to protect your property.
So for Angela's question, Clemson does not have a me. I end up answering questions for them. Um, you can reach out to their farm management team, and I know they work with someone in their general counsel's office with Clemson. And get that you can do that. You might look up Nathan Smith at Clemson, and Nathan can probably see if somebody there can help you. Hey, Michael, can you email all that to me? Because I can't, my computer's not letting me copy it. Sorry about that. Um, but yeah, if you reach out to Nathan Smith, he's like the lead of the farm management team. He may be able to direct help you with some of that. As I say, I think Tiffany and I end up dealing with a lot of Clemson's questions too. The South is pretty weird. There's legal specialists in a few states, but not all the states.
And there's a question about local offices. Is there one in each county?
What do you mean by reps in each county? Megan, can you give me a better example?
I mean, and I can tell you, like, so for the way that Maryland works, I think this
Oh,
is kind of what you mean. Should be a county extension office in every county in every state, which
yeah.
hopefully they have someone at least covering ag. You might not have a county ag agent, just depending on vacancies and stuff like that, and budgets, but there should be a county ag agent covering your county. It could be somebody from a neighboring county in certain situations. The way it works in Maryland, if you're in my county, you send me a question for something like this, as the county ag agent, I'm going to then forward it to Paul as our extension legal specialist for the state. I doubt, would there be any states that would have somebody local, or just be us kind of like ours where there's state specialists?
Be state specialist. You're probably going to end up dealing with me if she's in Maryland.
Yeah.
It's probably going to end up going to me.
All right. So if you're in Frederick, your county ag agent's Mark Townsend.
Yeah.
So get up, and it's going to be in the same office as 4-H. So just ask for him.
Yeah. And
And you
then,
can email Paul too if it's something legal, like leasing, legal type stuff.
yeah,
Yeah,
Mark
Mark
Townsend.
Townsend.
I was ready to say, yeah. And then if it gets down to specifics with some of the county code stuff, we'll have the ag marketing person help you in county government there. I can't remember who that person is off the top of my head, but they can usually help when dealing with zoning and planning and other random issues that come up with the counties.
You can pretty much call the extension office with any question. I just sent this out to we have about half of the people in my office now are new. And I did warn them. I said, I got a call asking for the number to the local pizza place one day in the county office. People call us with all random questions. So if you're not sure if it's anything to do with ag, certainly call the extension office, but we take all kinds of calls. So nobody's gonna think poorly of you because you sent them a random question. Yeah, there's a wrath of knowledge, Sarah.
Dave's knowledgeable.
No, she's in my county.
Oh, she's in your county?
It's a wrath of knowledge. It's probably more accurate.